Hey guys, before we dive in, quick disclaimer. I'm not a lawyer, I've never played one on TV, this isn't legal advice or really professional legal analysis. This is my best informed opinion of a fascinating case based on publicly available court documents and a little input from the plaintiff. If you need legal advice about your specific situation, talk to an actual attorney. Now, let's get into it. There's a case working its way through the federal courts right now that could, if successful, fundamentally change how California and potentially the entire country handles concealed carry permits. And nobody's really talking about it. While everyone's been watching May v. Bonta and the fights over SB 2's sensitive places restrictions, a low-voltage electrician from Riverside County named David Philip Vyos filed a lawsuit that doesn't challenge parts of California's CCW system. He's arguing that the entire concept of requiring law-abiding citizens to get government permission before exercising their Second Amendment rights is entirely unconstitutional, not just California's particular implementation. So who is David? David Vyos isn't backed by any of the big Second Amendment organizations. He's just a regular guy who got fed up with being denied his rights. He's an electrician, works as an apprentice farmer, has zero criminal record, no mental health issues, and isn't prohibited from owning firearms under any California or federal law. The California Department of Justice even confirmed in writing that he's not disqualified. He's also managed to get an FFL, too, and a CCW in another state. Anyway, he applied for a CCW from Riverside County in July of 2022. He was denied in June 2023, then he tried again in January 2024, and his application was withdrawn. His administrative appeal was denied in July 2024. Despite being legally cleared to own firearms and despite passing every background check, he can't get a permit to carry for self-defense from the sheriff's office. So on February 7, 2025, he filed a federal lawsuit representing himself against the California Attorney General and the Riverside County Sheriff. And I know how some of you guys feel about pro se cases. They make many in the firearms legal community a little itchy. But this case is happening right now, so we're going to talk about it. Plus, he has counsel now too. So here's where Vyos' case diverges from every other challenge to California's gun laws you've heard about. He is arguing that the criminal prohibition itself on carrying a concealed weapon without government permission violates the whole Second Amendment. So think about how this works in California right now. If you want to carry a firearm for self-defense in public, you can't open carry. That's effectively banned statewide for handguns at the time of recording this. And it's effectively banned for long guns. Your only option is concealed carry. But California law makes concealed carry a crime unless you have government permission in the form of a CCW license. Vyos argues that this creates an unconstitutional prior restraint on a fundamental right. And here's the kicker. California requires you to already own the gun before you can apply for a CCW. So you've already passed a background check to purchase the firearm. You've already obtained your firearm safety certificate. You've already waited through the 10-day cooling off period. The state has already vetted you as a law-abiding citizen safe to own firearms. But then California says you still can't carry that gun for self-defense without begging your county for permission. And if they decide you don't deserve permission, for whatever subjective reasons they want to use, you're just out of luck. Your constitutional right becomes a privilege granted or denied at the discretion of a government official. When the Supreme Court decided Bruen in 2022, it established a new test for Second Amendment cases. First, does the Second Amendment's plain text cover the conduct? Second, if it does, the government must prove the regulation is consistent with America's historical traditions of firearms regulation. As it turns out, every single firearms licensing law in colonial America targeted people who weren't considered full citizens. Virginia's 1619 law prohibited blacks and Native Americans from bearing arms unless they got a government license. Maryland did the same in 1715, South Carolina in 1740, and Georgia in 1755. These weren't laws applied to white citizens, they were explicitly racist laws used to control subjugated populations. After the Constitution and the Bill of Rights were ratified in 1791, the pattern continued. Mississippi's territorial legislature in 1799 required free blacks to get licenses from militia commanders or show sufficient cause to carry firearms. Maryland in 1806 prohibited any Negro or mulatto from keeping firearms without a license, from a justice of the peace. Louisiana, Delaware, Florida, North Carolina, all of them had licensing schemes, and all of them targeted racial minorities who weren't considered full citizens. In Dred Scott v. Sanford in 1856, the Supreme Court actually used this as reasoning for why free blacks couldn't be citizens. The court literally said that if blacks were recognized as equal citizens, they would have the right to carry arms wherever they went. And the court wasn't willing to grant them that status precisely because it would strip governments of the power to regulate their firearms possession. After the Civil War, Southern states immediately enacted the Black Codes that required freed slaves to get licenses to own guns. These were the Reconstruction-era versions of the old colonial laws, and Congress was furious. They took extraordinary action, passing major civil rights legislation to combat these restrictions. The Second Freedmen's Bureau Act of 1866 was passed over President Andrew Johnson's veto, specifically to use military force to guarantee freed blacks the constitutional right to bear arms, among other things, and to eliminate licensing restrictions that Congress viewed as unconscionable if they were imposed on white citizens who enjoyed full privileges of citizenship. So what's the pattern? For most of American history, licensing requirements were tools of oppression used against people who at the time weren't considered full citizens. The first general firearms licensing law wasn't enacted until 1911, New York's Sullivan Act, and even that wasn't really neutral. Contemporary evidence shows it was designed mostly to target Italian immigrants. But here's the crucial point. All of these early 20th century laws were immune from Second Amendment review. Why? Because in 1875, the Supreme Court ruled in United States v. Cruikshank that the Second Amendment didn't apply to state governments. The court didn't correct that error for the First Amendment until 1925, and didn't incorporate the Second Amendment against the states until McDonald v. Chicago in 2010. Now you might be thinking, wait, shouldn't the Bill of Rights protect citizens from their state governments too? And that's exactly what the 14th Amendment was supposed to fix after the Civil War. But the Supreme Court gutted that protection almost immediately in cases like Cruikshank, ruling that the Bill of Rights still only applied to the federal government. It took over a century of gradual incorporation, applying rights one by one against the states before the Second Amendment finally got protection in 2010. So all these state and local licensing schemes that started popping up in the early 1900s, they were never actually tested against the Second Amendment. They existed in a constitutional vacuum where the Second Amendment simply didn't apply to state and local governments. They can't tell us what the Second Amendment means because they were never subject to Second Amendment scrutiny. Now, Vyos claims, though this hasn't been fully documented in court filings yet that I've read, that he used Freedom of Information Act and California Public Records Act requests to uncover evidence that Riverside County and other counties are denying more permits than anyone really realizes, possibly because denials generate more revenue than approvals. If his claims are proven true in court, it would amount to a revenue generator disguised as a permitting process. On August 1st, 2025, the Federal District Court denied Vyos' request for a preliminary injunction. The judge's reasoning relied heavily on footnote 9 from the Bruen decision and Justice Kavanaugh's concurrence, which suggested that shall-issue licensing schemes remain constitutional. But here's where Vyos' attorney makes a pretty compelling counterargument. That footnote is what lawyers call a dicta, a statement that's not actually part of the holding of the case. Bruen was deciding whether New York's proper cause requirement was constitutional. The Supreme Court wasn't ruling on shall-issue systems. They explicitly said that they weren't ruling on shall-issue systems. They just noted that they weren't suggesting those systems were unconstitutional based on their decision in Bruen. The court even admitted that they were speculating when they said shall-issue regimes appear to be designed properly and appear to contain objective standards. They didn't actually investigate it. They didn't analyze the history, they just made an offhand comment while striking down New York's may-issue system. And critically, the court also warned that any permitting scheme can be put towards abusive ends, and they weren't ruling out constitutional challenges to shall-issue regimes, where, for example, lengthy wait times in processing license applications or exorbitant fees deny ordinary citizens their right to public carry. So the district court said Bruen endorsed shall issue systems. Vyos argues that the Supreme Court did no such thing. They just didn't strike them down in a case where that issue wasn't properly before them. Vyos appealed to the Ninth Circuit on August 27, 2025. He fought the entire district court battle by himself, representing himself pro se against the state's attorneys. But for the appeal, he now has professional representation from attorney Cameron Atkinson out of Connecticut. The opening brief was filed September 26, 2025, and it's one of the most aggressive challenges to shall-issue permitting systems that I've seen. The brief makes several key points. First, nothing in the Second Amendment's plain text requires seeking government permission before exercising the right to bear arms. The Second Amendment codifies a right, not a privilege that requires permission from the government. Second, even if Bruen's footnote 9 is considered, it doesn't help California. That footnote said shall-issue regimes might be constitutional because they appear to only require that those bearing arms are law-abiding responsible citizens. But California already determines that through the firearms purchase processes. You can't buy a gun without passing a background check, obtaining a firearm safety certificate, demonstrating safe handling with the firearm, and waiting 10 days. California has already determined you're law-abiding, responsible citizen when they let you buy the gun in the first place. The CCW permit requirement doesn't really add any additional safety screening, it just makes you ask permission a second time to carry the gun you already legally own. Well, and some redundant background checks, essentially. Third, the only historical analog to modern licensing schemes are surety laws. But surety laws were completely different. They presumed you had the right to carry unless someone made a specific showing that you posed a danger to a specific person or the community. They were temporary. They required a hearing with procedural protections. They targeted dangerous individuals, not the entire population. California's system does the opposite. It presumes everyone is too dangerous to carry and makes you prove you deserve permission. That's a fundamental inversion of the historical tradition. So as we've established by now, this isn't about whether California can require 8 hours of training or 16 hours. It's not about whether they can check your social media or require character references. Vyos isn't challenging any specific component of the CCW process. He's challenging the fundamental premise that California can criminalize the carrying of firearms for self-defense unless you get government permission. He's arguing that the entire structure, making it a crime to carry without a permit, is unconstitutional on its face. If he wins, it's not clear how California could construct a permitting system that survives. You can't require a permit if requiring a permit is unconstitutional. The case has the potential to push California towards constitutional carry, or at least force a complete restructuring of how the state approaches concealed carry. As of this recording, both sides have completed their briefing, the state has filed its response, Vyos filed his reply brief, and oral arguments before the Ninth Circuit are expected within the next couple of months. A decision could come by late 2026, though appellate timelines are unpredictable. Whether the Ninth Circuit will be receptive to this argument is anyone's guess. Historically, the Ninth Circuit en banc has been one of the most hostile appellate courts to Second Amendment claims. But Bruen changed the game. The question is whether the Ninth Circuit will faithfully apply the Supreme Court's history and tradition test or find ways to work around it. And if the Ninth Circuit rules for Vyos, this creates a circuit precedent affecting not just California, but all the western states in its jurisdiction. Well, folks, thanks for watching. Obviously, I want David to succeed in this lawsuit, because I agree with him that every state should be a constitutional carry state. If you guys found this video informative or at least entertaining, don't forget to like, share, leave a comment, and subscribe. You can also help out the channel on Patreon. Then I can get some better lighting out here. We also have a Discord server, and I am chronically online. As always, I've been the 2A Tactical Dad, and as I like to say, we could all be a little more free and a lot more self-reliant. All it takes is a little responsibility.